straight up on screen there, Henry, or just like this?
I already see you, so you can go ahead.
Okay. Well, I want to welcome everyone. It is start time, and we have a wonderful presentation here for you. When we really can't get to the office, everyone's been using a lot of their time for webinars. There are so many webinars out there that it's really difficult sometimes to know what to listen to and what not to listen to. So really at PACE, we decided what would be some of the best things that we could offer people, because you really can't come in. And we decided it would be really good to have Mariana and Dirk join us. Mariana and Dirk work at MBC Legal. It's a law firm in Oakville, and we've known them for a long time. I mean, a long time, and we've worked with them on many legal issues that really relate to the office. I have found them to always be available, very quick to respond to our concerns, and have really created some wonderful documentation for us that has worked well for us over the years. And you know, with that being said, I don't want to take too much of their time, so I'm going to get Henry to turn over to Mariana and to Dirk, and they can tell you a little bit more about themselves. And I'm really happy that they've taken the time. I'm not sure if they're wearing pajamas exactly, but since this, oh, Mariana is wearing her pajamas. Okay, good. Dirk, are you wearing your pajamas? We're not going to find out until you start talking. Okay. So why don't we let Mariana take this away. Henry, you go ahead and get started, and I hope everyone enjoys. And again, if you do want to send questions, send it through the chat, and we can make things happen. Okay? Have a wonderful day, everyone.
All right, Mariana, it's all you.
Okay. Thank you very much, Dr. Barzilay, for that lovely introduction, and thank you to PACE for hosting us today. Oh, I just want to make sure that my... Is my screen share on? Can you see my PowerPoint? Yes? Okay, thank you. Okay, thank you very much. Sorry, getting used to the new technology. Okay, so we wanted to spend an hour with you today talking about what you really need to know as employers about employment law, given the COVID-19 pandemic and coming out of lockdown. So we're going to try to break up the hour into three roughly 20-minute parts. In the first part, Dirk will go through some of the most frequently asked questions we've been getting about COVID since everything went crazy, I guess, March 15th, when the RCDS so strongly recommended that practices shut down to all but emergency services. And then in the following 20 minutes, I will discuss with you some of what we think is most essential in order for you to be prepared as employers leaving lockdown. And then we're going to try to leave the final 20 minutes for any questions you may have that we haven't already addressed in the prior 40 minutes. So without further ado, I will hand it over to Dirk to deal with the COVID-19 employment law FAQs.
Mute. Oh, there we go. Okay, I'm unmuted now. Thank you, Henry, and thank you, Isaac, for the nice introduction. I'm not wearing PJs. I don't wear PJs, truth be told. Okay, so anyway, let's get into the talk. So, FAQs is a little bit of a misnomer. When Mariana and I looked at all the questions that we've been asked, we sort of noticed that because things are changing so rapidly, a lot of the questions that we've been asked most are probably less relevant now than they were even a week or two ago. Okay. That said, there is one question that I did want to just sort of pull out of that list of most frequently asked questions, because I think it may still be relevant, and that is with respect to the CEWS program or the CEWS program, whichever you prefer, the wage subsidy program. And this is the program that allows employers to put their staff on, just sort of put their staff back on payroll retroactively, even going back to mid-March. And you get a subsidy from the government of up to 75% of the pre-crisis wage that they paid that employee. Now, if you're paying your employee more, which is probably not the case in dental, if you happen to be paying them more now than you paid them in the pre-crisis period, the subsidy would be 75% of what you're currently paying. Okay, now that's of course very unlikely. So, but the question that we had a lot was employers being very apprehensive about using the program because the Prime Minister and the Department of Finance had made statements that employers were expected to make best efforts to top up the 75% wage subsidy. And they were concerned that because revenues in most cases are next to zero on most dental offices, that they would not, if they needed to top up the wage, then they just would not use the program. And they were getting some of their advisors were saying, well, maybe you shouldn't use the program because of that best efforts language. I come at this from the perspective of, in my sort of prior career, I did about a dozen years of policy development at a provincial regulator, and during that time I also did a lot of legislative drafting, and I did postgraduate work in economics. So I sort of look at this program from the perspective of the overall policy goals of the program, and also how the legislation was drafted. So if you keep in mind that the overall policy goal of the program is quite clearly to not only keep a connection between employer and employee, so that the employee is not laid off and the employment relationship is broken between those parties, but the other significant policy goal is to put as much money into the hands of the employee as possible, during this crisis. So substantially more than they would receive in most cases under EI, and in a lot of cases more than they would receive under the CERB program. So the policy goal here is to get money into the hands of workers, and for the purpose not only of being nice to them and keeping them afloat, but to mitigate the medium and long-term risks to the economy as a whole. So the goal of the government is that let's get through this, and when we return to a more normal environment, the damage that we've suffered over this period is minimized. And one way we do that, as many of the European countries have done, is to use a sort of wage subsidy program to keep the money get money into the hands of those who need it most. Okay. The other significant thing to keep in mind is that the best efforts language was not written into the legislation. So it's not, if you look at the legislation that brought the wage subsidy program into effect, there's no best efforts standard in there, and that could have been drafted in there. So the legislative drafters could have put that in there, and it wasn't done. So again, it's not law. So for those of you who are still sort of considering whether to use the program, and you're thinking, well, my revenues are near zero. Yes, I do have money in my account, but I don't know what's coming next. I got to buy equipment. I don't know what my what my patient turnover is going to be like in the new world. My revenues are almost certainly going to be down. I would not be overly concerned about that best efforts language. Every client that I've spoken with who's been considering using it, I've encouraged them to use it and not worry about that. You know, as with all the guidance that we're giving, as with everything that we're saying, you know, your particular circumstances, you know, may be unique, may be different, and you should get proper independent advice with respect to it. But I just wanted to give people that comfort from the perspective of somebody who has done policy development, legislative drafting, has thought about these issues from the perspective of economics. I would not be overly concerned about that. It's moral suasion. Language is moral suasion. Marianne, is there anything that you wanted to add to that before I move on?
No, I agree with you. I think had the government wished to, they certainly could have put some teeth into that. So I completely agree.
Okay. I know we have some polling questions. Do we have one that's relevant to this that you wanted to ask, or should we save them until the end?
I did. I would like to ask a poll right now. Henry, if you could put the poll on for people. My understanding is that you need to have the most up-to-date version of Zoom in order to participate in the poll. I also understand that the poll is completely anonymous. So if I'll put it on the screen for those of you who don't have the most updated version. The question is, which of the following government programs have you applied for? CEWS, Dirk says CEWS, I say CEWS, the Canada Emergency Wage Subsidy. CEBA, the Canada Emergency Business Account, that's the $40,000 loan with $10,000 of forgiveness if you pay it off by the deadline. CERB, the Canada Emergency Response Benefit, or the Work Share Program. Please take a moment to vote.
Okay, I'm just going to continue. It looks like voting is something that can be done quite easily. So hopefully, if you have time to vote, but we also have a lot that we want to get.
I would like to know. Oh, there we go. Okay, we have.
Excellent.
We have the responses. Thank you so much, Henry.
Sorry, I'm going to have to. My eyesight isn't terrific, so excuse my close up here.
So it looks like 33% of people have applied for CEWS, 71% of people have applied for CEBA, 67% of people have applied for CERB, and no one has applied for your favorite program, the Workshare program, Dirk.
Okay.
Thank you everyone for participating in that.
Okay, that was terrific. Thank you for participating, and Mariana, thank you for thinking about that. That's very useful information for us. So I want to move on to scheduling tools, and according to the poll, nobody who responded to that poll has applied for the Workshare program, but I would encourage all of you to take a look at it, because in terms of scheduling tools, I think you might find that it is something that will become extremely relevant to a lot of you. So please have a look at it. I'll give you just a quick description of it now. Scheduling tools, now we're looking forward to reopening the practice, and we're now starting to think about, we're going to have a reduction in the sort of patient turnover, so our staffing needs will be lower, at least for a period of time, and perhaps significantly lower. So what do we do with staff over that time? What tools are available? I would say the number one thing you should at least consider doing is looking at the Government of Canada Workshare program. So you can search Government of Canada, Workshare, COVID, and make sure you're looking at a recent description of the program. If you see that the other COVID programs are listed on the website, then you'll know it's a current description. And I say that the WorkShare program has been available for many, many years. And the idea with the WorkShare program, but there have been changes that have been made to it during the COVID crisis to make it more responsive and more useful at this time. The idea with the WorkShare program is basically you're sharing the work among a group of your employees. So you take whatever work category it is, hygienists, assistants, receptionists, and you say, okay, look guys, in the next little while, I'm not going to need you at your regular hours. We're going to have a reduced schedule, and let's talk about how we're going to share the available hours amongst us. The WorkShare program does require that everybody who participates agrees to participate in the program, but essentially what it does is it allows employees to collect employment insurance for the hours that they would normally work but are now not working because they're participating in the program. And then, of course, you're paying them their regular wage for the time that they do work. Okay, so typically if somebody has reduced hours and the hours are reduced to the extent that they're entitled to EI, if they are paid a regular wage because you bring them in, that substantially reduces the EI. There's a reduction to the EI that they get then. So, but by using the WorkShare program, it allows you to keep everybody on staff. It allows them to collect EI for the reduced hours that they're being asked to work. So even if my suggestion would be take a look at the program. I'm sure, because we don't know yet what the RCDSO in particular is going to recommend in terms of upgrading, the necessary upgrades to IPAC and health and safety, that sort of thing. We don't know, you will not know, you likely don't know precisely how your scheduling needs are going to change, but I would suggest familiarize yourself with the program, and then if you think it's something that you might use, I would suggest you start talking to your staff and just introducing the program to them and saying, this is something that I think I might want to use. Think about what your particular needs are and how can you fit in? How can you make this work? How can we kind of pull together as a team? And you may find that your staff are quite cooperative, hopefully. With the COVID crisis, their summer plans have likely changed. The camps that they were going to put their kids in may no longer be available. So some of them might require some time off. So the WorkShare program might work quite well for you. Okay, so I strongly encourage you to familiarize yourself with that tool. Okay, now, what else is available to you in terms of scheduling? Well, what's available to you and how useful it is will depend, and Mariana will talk more about this, but it depends on what you currently have in place. So do you have proper contracts and policies in place? If you do, you have a much richer set of tools to select from. If you don't, you might not have a good set of tools available to you. So what are those tools potentially? Worst comes to worst, okay, the sort of capital punishment of employment law is termination. So hopefully we don't get to that, but if you're in a situation where you just cannot maintain all your staff, termination, of course, is a possibility. If you have properly drafted contracts, that minimizes the cost of termination. Mariana will speak a little bit more about that. Another tool that you may have available to you is the right to lay off. So many of you, perhaps all of you, have laid off your staff. If you have properly drafted contracts that give you a right to lay off, the laying off process was a very easy and safe one. In the normal course, if you don't have that contractual right to lay off and you lay off an employee, that's a constructive dismissal, and they can claim termination pay. If you have a properly drafted terminate or layoff provision and a properly drafted contract, you can lay off your staff. And the layoff rules across the country are different, but just speaking with respect to Ontario, a laid off an employee can be laid off.
Can I interrupt for 1 second? I just wanted to mention that a possibility is you may be able to lay off without triggering a constructive dismissal situation if we're in a frustration if the circumstances have hit the level that's sufficient to meet the legal doctrine of frustration. And I'll talk about that more in a few minutes, but I just want you to kind of keep that in the back of your mind.
Right. Thank you. So, you know, and Mariana will speak more about frustration, but if you have properly drafted contracts with a layoff provision in there, you don't even have to think about whether the doctrine of frustration will apply in your particular circumstances. So, you know, what does layoff entitle you to do? It allows you to lay off an employee for up to 13 weeks within any consecutive 20-week period. Okay, so a lot of you will have laid off your staff. Maybe you're getting to about the 6-week mark or so in the number of weeks you've laid them off. You can, if you bring them back onto payroll using the wage subsidy, that stops the layoff, and you can save those layoff weeks for use later. So once we reopen, if you do need to lay off staff again and you have that contractual right, then you can use your remaining weeks in your 20-week period. And as I said, if there are people watching from outside of Ontario, your rules will be different. But in almost every Canadian jurisdiction, if you have a properly drafted contract, there's a period of time where you can lay staff off without pay, at the end of which you then either have to terminate the staff member or recall them to work. Okay? So if you want to preserve your weeks of layoff, you can either bring them back onto the wage subsidy program, or alternatively, and what some of our clients are now doing, and we're assisting them with this, is they're reaching out to their staff members and they're saying, hey, there is there's a statutory leave of absence available to you. In Ontario, it's called the infectious disease emergency leave. So that's very easily available. It's very broadly drafted, very easily available to dental office staff. So some of our clients are reaching out to their dental office, to their staff, and saying, if you don't want to be laid off, if you remain on layoff, if we hit the 13-week mark, you'll be deemed to have been terminated. So if we'd like to avoid that, instead, you can let me know. You can opt into this leave of absence. We'll put you on leave. All of your the government assistance that you're receiving will still be available to you, but it is a leave of absence rather than a layoff. Okay, and the benefit from you as for you as an employer in that circumstance is that you then preserve those weeks of layoff for later use if you need them. Okay. Another tool that's available is vacation time. So again, if you have properly drafted contracts and policies, it'll be quite clear that you as an employer can dictate when your staff take vacation. If you don't have anything in writing and your historic practice has been that staff pick their own vacation time, or that it's mutually agreed to, or something to that effect, perhaps then you aren't able to dictate. And of course, we would have to look at every circumstance differently. But then if you're saying you got to take your vacation time now, that could possibly trigger constructive dismissal. Okay. Constructive dismissal, if they don't have a properly drafted contract, you could be looking at substantial termination pay in that case. So again, what tool is available to you depends on what you have in place currently. You know, the better your documentation is, the more to it. And Mariana's been doing these lectures for years and talking about, you know, what's in your toolbox. And you know, we see it every day. But in this crisis, it's really come to light how many tools there are available, and how it's helpful to have a bunch of them. All right, so you know, worst comes to worst in terms of scheduling, you may have to rely on termination. Hopefully not. You know, you can look at layoff so long as you have a properly drafted contract. Vacation time is possible. But the one that I would certainly suggest you all familiarize yourself with is the government's work share program. Okay. Well, one of the changes that's been made to that, incidentally, is that the time between the day that you're actually able to use the work share program and implement it in your office, the date that it'll take effect, is 10 days following the date that you apply for it. So you do need a 10-day gap before you're able to use it between the date of application and the date of use. And I would start already, and because it's something staff has to agree to, I would start communicating with your staff already. Mariella did an excellent presentation last week. And one thing that I, as an employment lawyer, really appreciated about what she was saying is that she stressed the importance of management communicating with staff about what they're doing to get ready to reopen. And so this I'm sure is the type of thing that she would communicate in Isaac's office. But I encourage you all to if it's, I don't know if that's available to look at. If you haven't seen the lecture, look at it. But that type of communication is very important, and I think it's very useful here as well.
Henry, is that still available?
The poll?
No, the Mariella's
presentation from last week. Can people still watch that?
Mariella's presentation from last week is what she's asking. Henry?
Yeah, it will be. We're currently just working out trying to get it.
Okay.
Oh, okay, great. Okay, thank you, Henry.
Okay. Okay, moving on. Another question that we've gotten a fair bit is what happens if a staff member says they don't want to return to work because they are concerned about workplace safety? So this is an individual who hasn't claimed a leave of absence, but is simply saying, I don't think the workplace is safe because of COVID-19. Across Canada, all employees have the right to do that under occupational health and safety legislation. They have the right to refuse work if they reasonably believe that the workplace is unsafe. So what happens if they do that? You can have them work in a space that they agree is safe. Now in the COVID situation, they're likely going to say the whole office space is unsafe. But your response to that is then to look at what you've put in place. You would, of course, look at the RCDSO or whatever province you're watching from, your provincial regulators' guidance with respect to health and safety and IPAC upgrades that you're required to make, and then ensure that you've put them in place, and then sit down with the employee and explain what you've done. If it's still the case that the employee refuses to return to work, then the next step in the process is to call the Ministry of Labor. They'll send an inspector to the office, and then the inspector will look at what the RCDSO recommendations are and the IPAC program that you have in place. And, see that the IPAC program is comprehensive, that you're training on it, and you've actually implemented it in your office. After the shutdowns that we had last year, where public health was going into offices and shutting them down, there was a big push on IPAC programs. And we've been getting calls from clients and non-clients about getting upgrades on what they have in place. We have, the program that we have is sort of turnkey. So a lot of the programs that are out there are sort of off the shelf, and your staff kind of have to figure them out and work through the program, and then sort of become experts on it on their own. What we have is something where our Director of Health and Safety, Maria Turner, she's an expert in this area. Anytime that I have a question, any health and safety IPAC issue, I go to her. And she has the answer. And what she does is she comes into the office. She basically does all the work. She spends a day or so in the office, and then prepares the program, comes back, does comprehensive training on it, training to all the staff, and then independent training for your health and safety committee. So it's a terrific program. She's getting a lot of calls on that. She is happy to speak with people, though. Be respectful of her time. If you're interested in speaking with her, get in touch with us and we can connect you. So that's an area that we've been getting a lot of calls on as well. Work refusal. How do I respond to it? What are the steps that I have to take? Okay. Lastly, We have been getting, sorry, I think I may be going a little bit over as usual. We have been getting,
Sorry, Dirk, are you going on to unionization?
Yes. Yeah.
Henry, can we do poll number 2 before we move on to unionization, please? So have you started to upgrade your IPAC program to get ready to reopen? Yes or no? Again, the answers are anonymous.
Okay, oh, there we go.
So we have 53% of people have begun the process, 47% have not. Okay, thank you everyone for participating.
Okay, thank you very much. Lastly, you know, some of you may know that the survey has been going around. I believe it was started by a hygienist in Ontario soliciting opinion on unionization. You know, we started thinking about the unionization issue a number of years ago when there was talk that dental assistants might be interested in unionizing in some offices. And in our look at the issue, we sort of thought, well, what are the reasons that staff unionize? It's you know, pay, it's working conditions, and it's you know, are my grievances being heard? Is there effective communication between my boss and me? And if I have an issue, can I take it to the boss, and will it be dealt with you know, fairly and equitably? So what we decided to do at that time was we encouraged when we encouraged our clients to include an open door policy in the policy manuals that we were doing for them. And this is a reminder both to staff and to the practice owner to have an open door, to listen to grievances. And really, if you've implemented that and you've heeded that advice, I don't think that you should be overly concerned about unionization in your offices. That said, what do you do if you have a concern now that you know, there may be some interest in your office? A couple things. One, you can talk to staff. You can ask them. You can talk to them about the costs of unionization. You can ask them what their issues are, what might cause them to be interested in unionizing. What you absolutely cannot do, however, is you cannot intimidate. You cannot attempt to coerce them. You can't promise them things if they vote against unionization. So really, what you have to keep in mind is that the right to unionize is very strongly preserved in Canadian labor law. Employees have the right to unionize, and you have to respect that. If you interfere with it, if you engage in any unfair practices to interfere with it, and that's learned of by the labor board if your employees have applied to get union certification, the union can be automatically certified. Okay, so avoid coercion, intimidation. Okay, if you have any questions about how to communicate with your staff or what you can do, please call us. One thing though that I would say is, the other thing to keep in mind about this is that if you get hit with an so if you receive a notice of application to certify to become a union, at that point, what you're able to do in respect of dealing with your employees is significantly limited. So prior to that, so in the stage that you're likely in now, you can ask them what their issues are, and you can make changes to the terms of employment to correct their issues, or you can negotiate something, you can change terms of employment. Once you get hit with an application to certify, terms of employment are frozen, you can't do anything about it at that point. So if you do have any sort of intuition that it may be an issue in your office, I'd encourage you to talk to your staff. And it's something really you should be doing on a regular basis. You should sort of have you should understand how your staff are feeling about things, and that you're dealing with grievances, that type of thing. Mariana, did you want to add anything to that?
Thanks, Dirk. Yes, please. I think, I mean, you sort of suggested this, Dirk, already, but I think it's important for people to recognize that if a union does come in, the first agreement that the parties are starting with is what was already in place. So even from that perspective, it's really advantageous to have really good contracts and policies in place, because that's what you're coming to the negotiating table with. I think it's also, I personally don't think that there's a huge risk of unionization in dental. We've been looking at this. I think there's been some attempt by union organizers to make inroads into dental for over 10 years now. And I think it's fair to say they've been pretty unsuccessful, not to say spectacularly unsuccessful. And I think that's for good reasons. Union membership worldwide is on the decline. And dental office employees are already extremely well paid. In our work, because 99% of our clients are some kind of doctor across the country, the bulk of them are dentists, but we have, certainly medical doctors, all kinds of doctors. You take the same skill set, say, a dental office receptionist, and you plunk that same person, same skill set into a medical office, and they're making dramatically less. So for skill set, dental office employees are paid very well. So there's not a lot that a union can offer them, in my opinion, to improve their position. And the union, unions are businesses. They need a huge part of why they're trying to make inroads into service industries like dental is because their union membership dues are drying up. And so they need to find dues somewhere else. And I think, hygienists are not stupid. They're going to recognize that the union dues have to come from somewhere, and it's going to come out of their compensation at the end of the day. So I don't think there's a lot that unions can offer dental office employees, and I think that's why they haven't been very successful at unionizing dental offices. But I completely agree with Dirk. A huge way to protect yourself is to have an open door policy. And that's why when we do our practice protection package for our clients, we always recommend that we include an open door policy in your workplace policy manual for that reason. So Dirk, if you are finished with unionization drive, I'd like to do the third poll.
Yeah, go ahead. Mm-hmm.
Okay, Henry, if we could have poll number 3. When you recall staff to work, do you plan to recall all staff or only some staff? So 47% of attendees will be recalling all staff, and 53% of attendees will be recalling only some staff. Very interesting, very interesting. Okay, thank you very much. Okay, so thank you, Dirk. We're moving on to part 2, essential preparedness for you as employers leaving lockdown. Dirk, please jump in anytime if you think that I'm missing something important. We really want attendees to get the most out of this hour that they possibly can.
Sure.
So, as we all are leaving lockdown and trying to get back to some semblance of normality, we think it's really important that you understand 3 very basic fundamental concepts in employment law so that you can understand your rights and responsibilities and your employees' rights and responsibilities. The first of those concepts is reasonable notice. Reasonable notice is one of the 3 ways that an employment contract can be terminated. The other 2 are frustration, which we'll talk about in a few minutes. If the contract is frustrated, the employee does not get pay in lieu of notice. And the third one is just cause. And if there's just cause for termination of the agreement, the employee does not get reasonable notice or pay in lieu of notice. But because of that, courts don't like employment contracts ending for any reason other than reasonable notice, because the courts in Canada are very, very protective of employees. If you put the jurisdictions of the world on a continuum, you would find Canada at quite left-leaning as far as protection of workers goes. So just cause is a concept that is very hard to meet under Canadian standards. We sometimes joke that you have to have you know, a dead body and a smoking gun and videotape evidence, and even then they will challenge the videotape evidence. So just cause is a really difficult standard, and courts don't like to allow employers to terminate agreements on the basis of just cause, because the employee then gets no protection from notice or pay in lieu of notice. So reasonable notice is by far the most common way that employment contracts are terminated. And there are 2 types of reasonable notice. And this is really important that you understand that, because it can be really confusing. There's the Employment Standards Act notice, which is it's statutory. It's set out in the Employment Standards Act. And it is essentially a week per year of service to a maximum ever of 8 weeks. Common law reasonable notice is much higher. And the courts are pretty adamant that they don't like us to talk about rules of thumb, because they want the discretion to award an amount that's very fact specific. But very, very roughly, you could say approximately a month per year of service to a maximum of 2 years. There are lots of circumstances in which that month per year of service will break down. So short service employees can get dramatically more than a month per year of service. Older employees can get significantly more than a month per year of service. If the employee was induced away from secure employment elsewhere, they could get much more than a month per year of service. But so in a nutshell, you have the Employment Standards Act, a week per year of service to a maximum of 8, or common law, a month or more per year of service to a maximum of 2 years. Very significant difference, obviously. And it's important that you understand that I think a lot of the confusion comes from the fact that people think if they comply with the Employment Standards Act, they fulfill their termination obligations to their employee, but it's not true. Employment Standards Act minimum only unless you have an enforceable contract that rebuts the common law presumption. And believe me when I say there are thousands and thousands of pages of case law on what constitutes an enforceable agreement that rebuts the common law presumption. It is absolutely doable. It is achievable. The courts are clear that we can, as employers, rebut the common law presumption, but we have to dot every I and cross every T. I wouldn't want to leave you with the impression that it's some impossible feat. It's not. We do it every day. We just, recently won 2 cases in which the court not only approved the contracts, but ordered the employee to pay our clients, the employer's costs, legal costs. So it's absolutely doable, but you have to dot every I and cross every T. At our firm, we're often asked to review contracts that have been drafted by someone else, and in the overwhelming majority of the time, they're literally not worth the paper that they're written on. So it has to be done properly. So again, the situation that you're in as an employer, if you need to an employee, is vastly different if you have the contractual right to terminate with minimal Employment Standards Act notice versus if you don't. If your contract is unwritten or poorly written, such as a court would not enforce, then your obligations on termination are the very expensive common law terminations. If you do a quick calculation of the people on your team, compare the difference between you're giving them a week per year of service to a maximum ever of 8 weeks with a month or more per year of service to a maximum of 2 years, and you can see it very quickly adds up to hundreds of thousands of dollars of difference. So reasonable notice is the first of the 3 legal concepts we think it's essential that you understand as we all leave lockdown and try to return to some sense of normality. The second legal concept or doctrine is constructive dismissal. A constructive dismissal is a unilateral and substantial change to the terms of employment of the employee without their consent. So any significant adverse change to the employee's terms of employment without their consent could trigger a constructive dismissal lawsuit. Certainly a layoff, as Dirk was saying earlier, if you don't have a clear contractual term, then a layoff is technically a constructive dismissal. If you're watching this at home and you have our trademarked practice protection package, then you almost certainly have the right to lay off. We would have offered it to you. It's unlikely you would have said no. Most people take that option. So if you have a PPP, you almost certainly have the right to lay off. And so we want you to understand that it's, as Dirk was saying, how much flexibility you have to manage issues coming out of lockdown as an employer really depends very much on what is in your toolbox, and whether you have, again, if you have contracts that permit make significant changes to hours, duties, reporting relationships, then you have a contractual way to prevent a constructive dismissal lawsuit. Just as with, if you have a good contract that specifies that the notice that you have to give on termination is the Employment Standards Act reasonable notice, then that obviously gives you a lot more flexibility to deal with things coming out of COVID. So the third legal doctrine that we think it's essential for you to understand as we all leave lockdown is what's called frustration of contract. There's been a lot of talk and publication about frustration of contract in the media generally, because it applies not just to employment law, but to any contract. Frustration of contract is a common law doctrine, and it means that the contract is impossible to perform because of some unforeseeable event due to no fault of either party. So there's a lot of disagreement among lawyers about what elements of COVID, if any, constitute frustration of contract at law. And of course, whenever lawyers disagree, that means there's going to be a lot of litigation. And we absolutely expect there to be many, many months of litigation around what things have happened to employees that constitute frustration, whether or not they do. I think it's important to kind of take a 10,000-foot altitude perspective and recognize that historically, economic downturns, no matter how bad, have generally not been sufficient to constitute frustration at common law, because the courts consider them reasonably foreseeable in a market economy. In a capitalist market economy, there's economic fluctuations. That's perfectly foreseeable. I think when on March 15th, when the RCDSO strongly recommended that dental offices close to all but emergency services, I think a strong recommendation is probably not sufficient to constitute frustration. Arguably, a week later, when the Ontario government shut everyone down, arguably that was a frustration for the purposes of the layoffs, the temporary layoffs. But the offices weren't shut down forever, so I don't think the contracts were entirely frustrated. I think it's really important to recognize that the doctrine of frustration is concerned with who should bear the risk of unforeseen events. And in Canadian law, courts have a very strong pattern of protecting employees. So I think it's reasonable to anticipate that they're going to go to great lengths to protect employees. If the pandemic lockdown in March of 2020 did constitute frustration, I think it's pretty clear that no pandemic going forward is going to have the same status, because we now, maybe we could have said in March these things were unforeseeable, but no one going forward can say it's unforeseeable. We all now know or reasonably anticipate that it's going to ebb and flow, the very significant interruptions in our normal business dealings. So again, we're going to see litigation about frustration, I think, for many months. But given the very strong pattern that Canadian courts have of protecting employees, my advice to employers would be not to put a great deal of reliance on the doctrine of frustration.
Okay.
Sorry, Dirk,
yeah.
go ahead.
Well, I've just been looking at questions, so we do have a few minutes left, and I thought, if you're done with what you wanted to talk about, maybe I could start going through some of the questions.
Sure. Can I just wrap up very quickly?
Yeah.
In a nutshell, what we think is really important is that you have some essential management rights coming out of lockdown. Like, as we're leaving lockdown, we need to have some essential management rights. As Dirk said, I've been banging this drum on management flexibility since 2003, so for about 17 years. But the pandemic has made it more essential than ever that you have, the key word is flexibility. You need to have management rights that any well-run business would normally have, but now it's going to be absolutely essential. You need to have the right to lay off. You need to have the right to terminate with minimal ESA notice. You need to have the right to change hours, duties, reporting, relationships, all kinds of things. The key word is flexibility, so that you can ramp up and down your workforce as conditions change. Remember that unwritten does not mean flexible. The courts will not give us the benefit of any of these flexible management rights unless we have a very well-crafted set of contracts and policies that clearly spell those out and that are strong enough that a court will enforce them. And then I just wanted to say very quickly on the effect of COVID on practice values, because a lot of doctors are talking about what the impact of the pandemic has been. Our advice is to keep calm, and if you can use the remaining downtime to get your affairs in good order, even better. Your practice value, we believe, is safe. Remember that everyone is going through the same circumstances. It's not as if your patients are going elsewhere. They just can't see you. But as soon as you reopen, they will come back, and there will even be some pent-up demand. So while no one has a crystal ball, we think that practice and market values will remain strong for those who are well prepared to exit ownership in the next 12 to 18 months. At NBC Brokerage, we're also working with all the Schedule 1 or most of the Schedule 1 banks to account for the COVID-19 anomaly to mitigate major losses in practice value. We think it's reasonable to expect an adjustment in these circumstances because all dental practices are in the same situation. So again, when it comes to worrying about what the pandemic has done to your practice value, keep calm, and if you can use the downtime to put your affairs in good order by getting your appraisal or updating your appraisal, so much the better. Can we quickly do the poll questions, Dirk?
Of course, yeah. And then maybe we should ask Henry if we're able to go a few minutes over just so we can get through some of the attendees' questions.
Yeah, you can go over. Don't worry about it.
Okay. Okay, great. Thank you.
So question number 4. Do you have a written contract signed with all staff that permits you the flexibility I was talking about to make the management changes you may need, laying off, changing hours, duties, reporting relationships, maybe location of work, who knows, without triggering a constructive dismissal lawsuit? So 41% of people believe they have an enforceable agreement that permits them to make flexible management changes, and 59% do not. Very interesting. Thank you very much, everyone. And then very quickly, polling question number 5. Has the pandemic changed the date that you expect to exit practice ownership? Yes, I now plan to exit ownership sooner. Or yes, I now plan to exit ownership later than I originally planned, or no change. So 24% of people expect to exit ownership sooner. 18% of owners expect to exit later than they originally planned, and 58% have no change. Very interesting. Okay, thank you so much, everyone. Okay, so let's take a few minutes to answer questions that have come through that we haven't yet touched on. Dirk?
Yeah. Okay. So I've just been scrolling through the list of questions. We're almost at the hour, so I'm going to try to go through them quickly. But thank you for submitting your questions. So we did want to address them. Let's see. We've got some good mornings, of course. Okay. So if you move an employee to the wage subsidy program, can you put them back on EI after that? Yeah, so the wage subsidy is you're bringing them back onto payroll. They're no longer laid off, and then you can remove them from payroll. So you can lay them off. You know, now that depends, of course, on, as we've stressed throughout this talk, it depends upon what contractual rights you have. So if you take them off payroll, that may trigger a termination. And while a lot of employees who you could not, with respect to whom you did not have a contractual right to lay off, a lot of employees may have accepted a layoff in this COVID crisis initially. You might find later that they might not accept being laid off. So they may have accepted it the first time, they might not accept it the second time. That said, if you have a properly drafted contract, it's the choice is yours, not theirs. Okay. So what happens if a staff member does not want to use the wage subsidy? You can require your staff to come on to payroll. Now, of course, you have to be eligible for the program. You've got to meet all the requirements of the program, and you have to be paying staff their wage in order to receive the subsidy. But a lot of our clients are giving staff the option. They're saying, would you like to use the subsidy, or would you like to remain, would you like to use CERB? Those are usually the two, because some of your staff may be better using CERB. So you don't have to use the wage subsidy for everyone. You can give them the option. Does CERB cut into the EI time, i.e. the 13 weeks? No. If they're using CERB, they are still laid off. Okay, they're not back on payroll. CERB is not a payroll program. If you're using the wage subsidy in respect of the employee, yes, they're not laid off during that time. Give us an example of a work share program, employee A, employee B. So, I mean, let's say you've got two hygienists, they're both working 5 days a week. You think you can only now supply half that time. So maybe you use an alternating schedule. One gets 3 days one week and 2 days the next week, and the other one gets the remaining hours. So you could schedule it like that. You pay each of the employees their regular wage for the time that they're working, and they get EI for the remaining time. Do you need to bring back all your employees? So when you recall your staff, you don't have to bring them all back. You should be, you know, if you don't bring someone back, it's a termination. So then you have to, there are all kinds of considerations that you have to be mindful of there. What are your contractual rights? If you don't have a properly drafted agreement, you may be looking at significant common law termination pay. You also have to think about who was the particular employee that you're terminating. Have they taken a leave of absence prior to COVID due to, say, maybe they've had a mental, a disability. So maybe they took a disability leave prior to COVID. And so, perhaps they'll say, well, you didn't bring me back because I took a disability leave. And so you have to be in a position to show that their disability leave was not a factor in your decision to not bring them back. That's a very case-specific, complicated issue. So this is not legal advice on that particular situation. That's something that you really have to talk to someone about. Okay, but generally, you don't have to bring everybody back, but those who you don't bring back, You got to be careful of who those employees are and what the background is, what the particular circumstances are. So the statutory leave of absence applicable to staff without employment contracts. The answer is yes. Everybody has employment contracts. They're either written or unwritten. Okay, so I mean, we say employment contracts meaning written employment contracts, but you know, the reality is that they all have employment contracts. So yes, the statutory leaves of absence are available to all employees. Okay.
Someone asked, what if one of the staff says no? Meaning, I think the question means if you're transitioning them to proper contracts and one of them doesn't want to sign the contract, which is one of the most common questions that we get. The answer is, if you do the process properly, they don't have any choice. They get reasonable notice of the termination of their existing, largely unwritten or maybe partially written contract. So we give them reasonable notice that that their current contract is ending, and then we give them a new contract offer. Provided the process is done properly, their current contract ends with working notice, and at the end of the working notice, that contract is over, and there's really nothing they can do about it. And then it's up to them whether they choose to sign the new contract or not. But if they don't, we don't owe them anything. Again, if the process is done properly, often we are brought in to fix situations that are bungled, and there are lots of things that could be done improperly, because remember that a court is always looking for a way to protect the employee whom they perceive to be vulnerable. So there are all kinds of sort of traps for the unwary, but when it's done properly, which is our job, there's really nothing that they can do at the end of their reasonable notice period.
Yeah, if they go to the end of the reasonable notice period and they've decided to not sign the contract, which is exceptionally rare, actually, then you've provided.
Of the time. Last time we polled our clients, fewer than 1% of the employees who were presented with the new contract that we had prepared for the client, fewer than 1% of the employees didn't sign. And remember, we've been doing this for 17 years. We have transitioned thousands and thousands of dental and medical office employees across the country. It's very rare, as Dirk says, for them not to sign.
Yeah, so just to finish the thought, if they do get to the end, in a rare circumstance they haven't signed, they've received their reasonable notice, they're entitled to no more than that. They're not entitled to termination pay at the end of that time. You gave them time, if they didn't want your contract, to look for another job. That's what the reasonable notice period is for. Okay, so I'm just going to continue through the...
I just wanted to add, we just won a court case on behalf of one of our clients, which the employee was claiming she didn't sign the contract, and she wanted, I think it was $30,000 or $50,000 or something like that. And we told our client, you don't or anything. And, took our client to small claims court, and we not only won the case, but again, the court ordered that employee also to pay our clients legal fees. So.
Okay, what should we tell our associates about PPE? Should they be getting their own? This really depends on what agreement you have with the associate. You may have a written agreement that says you will provide all the regular tools and equipment, and if they need something extra, they're required to get it themselves. So if you don't have something in writing, it's based on your historical practice. Of course, if they agree, you know, then you know, you can have them get their own PPE if they agree to that. Am I responsible for purchasing PEE reusable gowns for staff? Again, it depends on what your practice has been in the past. In most offices, I think you would find that the practice owner is the one who is going to be purchasing that.
And under the Occupational Health and Safety Act, you have an obligation to maintain a safe workspace. And what that means depends on circumstances. And, you know, arguably during a pandemic, that's what that means.
Yeah. Yeah, can an associate apply for government programs? Yep. So that might be the CERB or that would be the one that would most likely be available to them, unless they're on payroll, in which case they can also maybe get the benefit of the wage subsidy if their principal wants to do that, but they're likely not going to be on payroll, so it'd be the CERB that they would look at. Do we need to sign new contracts with staff who've gone on EI? So new contracts needed for associates. So again, you know, you have a contract anyway. It's just written or unwritten. So when you recall them, if they're not on a written contract, you're recalling them to an unwritten contract. So they will be on a contract. Of course, you know, our strong advice is get a proper written contract in place to put more tools at your disposal. What if the office is not on contracts? Can we do and have, yes, can we put staff on contracts? Yeah, so this is something that we do all the time. We are approached by offices who want to transition their current staff from either poorly drafted, unenforceable contracts or unwritten contracts to you know, the contracts that we do. So that's, we do that all the time.
In fact, we've seen a real surge in demand for what we call the practice protection package. That's sort of what we're known for, comprehensive contracts and policies. And I was interested to see it sort of surge pretty quickly after the lockdown. And I think it's because people recognize that they need these management tools. They're going to need management flexibility now more than ever.
Yeah. So, okay, so some of these seem to be repeats, so I must skip some. So I've offered wage subsidy to some, and some employees didn't want to take the wage subsidy. What do I do with the rest who have opted out? Well, they presumably are remain laid off. One thing that you can consider, well, I mentioned this in the talk, I'm quite sure I talked about the availability of leave of absence under the Employment Standards Act. So you can contact the ones who decided not to take the wage subsidy, and you know, we suggest you do all this stuff with legal advice, of course, but you can ask them if they would prefer to be on a leave, because they may have done a calculation and said, well, I would rather get the CERB than 75% of my pre-crisis wage. So I prefer the CERB to the wage subsidy. I would prefer to be remain on layoff in that case.
Can I just add, Dirk?
Yeah.
I wish it were possible for us to give you a very clear kind of flow chart. If this, then that. But whether or not your employees are laid off or on the infectious disease emergency leave does pretty significantly affect your rights and their rights. And it's a little bit complicated.
Yes.
It's not possible for us to say, as an employer, it's always in your best interest to do A or to do B. It really depends on the circumstances, and just from a, you know, professional liability insurance perspective, I don't want to be seen giving you kind of careless advice. You have to be careful, because as a general proposition, it's not in your interest as an employer to have staff on a statutorily protected leave, because it adds, you know, cost and uncertainty and to your business.
Yeah, one simple thing. Yeah, just you know, if you later terminate somebody who was previously on a leave of absence, you know, they can claim that the termination was a reprisal. So they can say, you know, you terminated me because I took it, you know, I was on a statutory leave of absence, and you know, you then will have to effectively show that their having taken the leave of absence was not a factor in your decision to terminate. And showing that, you know, if you don't have good documentary evidence, it may at times be difficult. So this is an excellent point that Marianne is making. I may have suggested that it's really always attractive to use the leave option, but that's not necessarily true. So the general caveat, you always have to get advice with respect to each of these issues for your office.
Yeah, it will depend on a lot of circumstances. You know, do you have good contracts? Do you have the right to lay off? Do you have the right to terminate inexpensively? If you have those rights, then you're not as worried about your layoff clock running out. Remember that if the layoff clock runs out at 13 weeks, it's a deemed termination by statute. You are deemed to have terminated those people, and then they get whatever are their termination rights, whether they're Employment Standards Act, because you have good contracts, or they're common law, because you don't. This is all assuming their contracts are not frustrated, because at that time we are in a complete shutdown or something like that. But again, I wouldn't put a lot of faith in the doctrine of frustration, because it is about allocating the risk of an unforeseen event. On whose shoulders should that risk lie? And courts have demonstrated over and over and over again historically that they don't generally put the risk of a loss on the relatively vulnerable employee.
Okay, so I'm just going to continue going through the questions. There are a couple of questions here about reducing wages. So one person had given somebody a wage increase just prior to COVID, but a couple of people are asking, well, what about reducing the wages after COVID? So this is the sort of constructive dismissal situation that Mariana was talking about. Again, if you have properly drafted contracts, changing any term of employment is easier, quicker, and cheaper. If you don't have proper contracts in place and you are changing a term of employment like pay in a way that is substantial, and to, you know, if you're reducing pay, obviously it's to the employee's detriment, you can be triggering a constructive dismissal. So whether you're able to do it without risk very much depends on the particulars of your situation.
Sure. Could you speak to if people don't have good enforceable employment agreements that allow them to reduce wages or make changes to compensation, what do you think is the threshold that they could get away with before it hit constructive dismissal? How much of a drop in compensation?
Well, you know, traditionally is sort of the ballpark number of 10% is used. So that's commonly what one sees in the case law. So a reduction of net, you know, compensation, whether that results from a pay reduction or reduction of hours, that is, you know, at or below 10%. But again, I would say, you know, you've got to. This isn't saying that you can do that in your circumstance with impunity. You've got to get legal advice on it, of course. But that's sort of the ballpark number. Yeah. Do you need to pay attention to seniority when thinking about bringing staff back? You know, that would be the case under a collective agreement, likely, if you have a unionized environment, but not otherwise. You might want to be mindful of seniority just for the reason of termination pay that would be owed if you don't bring the person back. So if it's a situation where not bringing someone back results in you then having to terminate them, a more senior person on your staff, you know, if you don't have proper contracts in place, can be very, very costly, up to 2 years' pay in some cases. I think the law shouldn't be enforced during this unusual time. Yep, I'm, you know, that's sort of a, let's go back to feudalism, I guess. But no, I mean, I'm being facetious, but you know, this is what Mariana was talking about with respect to frustration. So there is a doctrine in law that contemplates, you know, unusual and out of hand situations, as this commenter puts it, that might mean that you know, the fulfillment of a contract, neither party is at fault for failing to fulfill a contract, but again, you got to look at the particulars of the situation. How can we be sure if our written contracts are strong enough? Well, they've got to be reviewed by a lawyer. You know, and
a lawyer who works in I would say who practices exclusively employment law.
Yeah, as Mariana said, you know, there are thousands of pages of case law written on this. You know, from the contracts that I've reviewed, the associate agreements tend to be much better done than employment agreements. I would say a very, very high percentage of employment agreements that I've seen are not worth the paper they're written on, like well over 50%. So how do you know if they're strong enough? You know, they should be reviewed by a lawyer.
And we're happy to give you a second opinion. Contact us. Our contact information is on your screen. We're happy to give you a second opinion on your agreements. Within that, I think less than 10% that are likely to sustain an attack from an employee side lawyer, we'll let you know. And if not, we'll let you know.
Question about associate independent contractors and terminating them possibly without notice. Again, it depends on the what agreement you have in place. It also depends on whether they are truly an independent contractor. There's this idea at law of dependent contractors. So somebody may not be on payroll, they may not be an employee, but if they are a dependent contractor, and you look at a number of factors to determine that, one is economic dependency on the principal. So if this person is getting 60 or 70% of their income from one office, they may be a dependent contractor. And so if you don't have a proper termination provision in place in respect of them, you could be looking at something that would be akin to the termination pay that an employee would receive. So again, it's can't answer that without looking at the particulars, but that gives you some notion. Okay. Mayor, if you want to pick off any of these questions, I'm just sort of trying to find ones that are how much in terms of how much. Okay. I'm sorry, I'm having trouble understanding some of these, so, and I don't want to waste people's time. So, is there a deadline for applying? Is there a deadline for applying for wage subsidy? Yes, there is, but I think it's in October of this year, so you do have a long time to apply for the wage subsidy. Can you apply for the wage subsidy after the serve period is over? Well, in order to have the wage subsidy available to you, you have to have paid the wage. So if they've been collecting serve and you haven't been paying their wage during a period of time, then you can't receive a wage subsidy in respect of that period. Now, the wage subsidy program has this retroactive notion so that if you haven't been paying the wage, you can say, well, I will now pay the wage in respect of this period that I formerly did not pay them a wage, but I'm going to do it now in respect of this prior pay period, and then you can get the wage subsidy for that prior pay period. I hope that helps. Mayor, did you have one?
Just one final question. What are your thoughts on wage reductions upon return due to increased costs and decreased revenues? So I think we touched on that a little bit. Again, we're big believers that as employers and management, you need to have tools in your toolbox that allow you to deal with all kinds of unforeseen events. So if you have the contract that permit you to make, to reduce someone's wages without triggering a constraint you have in your toolbox, then you need to do what you need to do for the business to function. I mean, after all, if the business isn't functioning, no jobs for anyone. So, so if you have the legal right, then yeah, that's a great tool. It's just that a lot of people may be surprised that their contracts, they may be surprised either at how strong their employees' rights are in the face of an unwritten contract. And similarly, they may be surprised at the fact that what they thought were their contracts are actually probably not enforceable, or they're weak enough that an employee side lawyer will think it's worth taking a run at them. So anytime you're making a change to, and that's why we were talking about constructive dismissal, anytime you're making a significant adverse change to an employee's terms of employment, you have to be very careful, because those are the high risk situations that can trigger a lawsuit.
Okay, can I?
So,
Oh, sorry.
yeah, please.
Okay. How about associate contracts? Can you change terms? So again, it depends on what you have in place, at what the termination provision is. But at the end of the day, if they agree to the change, then the change can be made. All of these are with the caveat, you know, we can't provide legal advice with respect to your particular situation. This is just sort of, you know, general understanding of the issue. Okay. Is now a good time to have the consultant look at IPAC, or wait until our CDSO recommendations? Well, I would say, you know, start early, because Maria can talk to you about where you are currently, what the strength of your IPAC program is currently. And, you know, of course, there is a lot of IPAC stuff that you should have in place today. So if your program is currently deficient, it may be the case that she would recommend, well, let's get started on it. And then once we get the regulators' recommendations, we can fit those in after. So we, of course, have a bunch of clients who have already gone through the IPAC process with us, and Maria will be preparing documentation to slide into those programs once we learn what the RCDSO recommendation is. So you can certainly get it done now, and then sort of slide in the enhancements that are required.
I think there's some value to getting into the roster, because we'll have to go in the order in which people are approaching us, and I expect it's going to be a bit of a deluge on the IPAC and health and safety programs because COVID.
Sorry, go ahead.
Two questions are asking what I think is the same thing. If you already have a PPP, so practice protection package from NBC, like good contracts and policies, do employees require a back to work agreement after layoff, even if terms and conditions are the same? No. If I understand the question correctly, no, they're just laid off, and you recall them, and the terms of their contracts just continue.
There's a question here about responsibility. So waiving, do you have to get an employee to sign a waiver if they come back to work and get COVID? So this is, you know, potential liability at work, and you know, do you want to?
Do you have to get them to sign a waiver if they get COVID? In other words,
that's my, yeah, go ahead.
Waiving your legal liability if they get sick?
I think that's what the questioner is intending.
I would be very surprised if that were legally effective. I would be speaking with your insurance company right now. I guess for most people watching, it's probably CDSPI. But talk to them about what insurance coverage you have in place, and you know, what would happen if an employee got sick from COVID, and see what you can do about getting good protection in place. I would be surprised if you could waive your liability, because that liability really fundamentally depends on a statutory regime that's pretty robust. The Occupational Health and Safety Act requires you to maintain a workplace that's safe for workers. So I just don't think you could contract out of it by getting someone to sign a waiver. I think insurance coverage is important, and ensure that you have you know, the best coverage that's available. Dirk, do you want to mention WSIB? Someone was asking us about WSIB the other day. And
no, you go ahead.
I'm not a big fan of WSIB for a lot of reasons. for 17 years now that I've been working in dental, I've always taken the view that if you are able to opt out, in other words, if registration with WSIB is optional for you, as it is for dentists and indeed lawyers, then I think you're better off not participating in the regime for a lot of reasons. I think the coverage is the wrong coverage. So you're paying premiums to protect employee wages, which is not a good legal match for your legal liability. The insurance coverage you want to be paying premiums for is your legal liability, which, you know, isn't necessarily a good fit. And then you're paying premiums in WSIB for actuarial studies tell us the more disability insurance someone has, the more time they spend away from work. So it's an economically irrational expenditure for the business to make to get a result that is the opposite of what is in its business interests. So you're paying a higher premium to have greater absenteeism. And I think the reality of it is an employee is pretty unlikely to sue an employer with whom she or he continues to want to have an ongoing relationship. Like they may be likely to sue you at the end of the relationship, but during the relationship, while they still want to work for you, they're pretty unlikely to sue you. But that's not the case with WSIB. If someone is injured on the job and they know they have coverage, I think they're not at all disinclined to make a WSIB claim. They don't feel like, well, I'm suing Dr. Jones. They just make a WSIB claim. So for all of those reasons, I think you, as an employer, you're not at all advantaged by having WSIB. And at least so far, nothing about COVID changes my view on that. I would speak with your insurance broker and see what coverage you have and what coverages you can implement best to protect yourself. But I don't think WSIB is it.
Okay, let's try to, maybe whip through a few more questions. They do keep coming in, but I think we're over, half an hour over our time, but we would like to help you guys out. So does the work-share program eat up the 13 weeks of EI? The work-share program, historically, it's available for up to 38 weeks. I think it's been extended with the COVID amendments to double that. Do I have to pay? Well, we've talked about that earlier, the 25% top up on the wage subsidy. The Congress paying. Colleague, yeah, okay, another wage subsidy and the obligation to top it up. It's not required by law to top up the wage subsidy. Marianne, I think you answered this question about bringing people back to work and having to sign an agreement. Re-sign if the PPP, if we have a PPP, okay. That one you've answered. That's another, sorry, there's some repeats in here. Staff want to use CERB and stay laid off. Yeah, that's fine. Or they want to use the CERB only but not be laid off. Okay, well, they're either on payroll or not on payroll. CERB is not a payroll program. So in that case, I mean, again, you can have them on a leave of absence. So, get employment law advice, but the employee may be able to go on a leave of absence that would not then be a layoff. Okay, we got another question here about lowering wages. So I think we've talked about that a number of times and the potential there. If you don't have proper tools, the constructive dismissal risk. Okay, what allows the 35-week option with staff agreement? Okay, that's a little. I think what's being meant there is, there's in the Ontario Employment Standards Act, an employee can be laid off for up to 35 weeks for a 52-week period, so long as that's typically not something we've ever had a client who's been interested in doing that. So I did mention it earlier, and a substantial portion of their wage has, generally been interpreted in the case laws as at least 50%. Okay, what are the chances of the Ontario government extending the 13-week layoff period? It's possible. I think that there's a decent likelihood that they will do that, but I haven't heard anything to that effect. So the Ontario, now other jurisdictions have. Alberta, for example, extended its layoff period from 60 days to 120 days. So other jurisdictions might do that. In Ontario, they might be thinking, well, we've made this leave of absence available, so employees can be converted to that. As Mariana pointed out, though, leave of absence and layoff have very different legal implications. So they're not a perfect substitute for one another by any means. So they may do it. I've heard nothing about that possibility though yet, but it does make sense. It does make sense. It's a sensible thing to do.
Related, someone's asking, if you don't reopen prior to the temporary layoff termination period of 13 weeks, can you have employees go on IDLE, the infectious disease emergency leave, before the 13 weeks to avoid termination and continue the employment relationship? In a nutshell, yes, but it's up to the employee. You can't force an employee to take the leave. It's just like an emergency leave or a parental leave, or it's their option whether they want to take it or not. But presumably employees are going to be fairly cooperative, hopefully, during this time, because they recognize that business is down, and unemployment is going to go up, so it's going to be difficult for them to go elsewhere. It's going to be much more cooperative than normal, and I think one of the reasons a lot of people want to transition their staff at this time to good contracts and policies is also because I think that staff will be much more receptive than normal given the unprecedented nature of our circumstances right now.
Okay, so another questioner asks, the questioner notes that if an employee is on CERB, they can receive up to $1,000 of income during that time without affecting their CERB, and she asks, or he asks, is the same the case for people who are on EI benefits, or do the pre-COVID rules apply? Still, the pre-COVID rules apply. So any amount that they receive as income will be deducted from the EI that they receive. It's 50 cents for every dollar that they receive. And now there is what's called a sub program. So this is it's a complicated program to set up, but basically the idea is that if you have an employee on EI, you can contribute to their top up their EI without having any reduction of that EI. But I think this questioner is thinking, if I bring them back to work, what effect will that have? So I think I've answered that now. Another questioner, well, okay, so this is about hygienists reducing work time and what recourse is there. I think we've discussed that. That was, we talked about scheduling tools, look at the work share program, and then consider what other tools you have in your sort of toolbox. And this depends on the contracts that you have in place. Are you able to require them to take a layoff or vacation time?
A quick question. Someone's asking, if staff were to take a leave of absence, do they need to put this in writing to us? And the answer is no. They can tell you orally. They can tell you in writing if they choose, but they can also tell you orally. A big problem with the new leave, IDLE, I-D-E-L, infectious disease emergency leave, is if an employee does not act in good faith, there's just a tremendous room for abuse of it, because theoretically they're supposed to tell you in advance. but they're not disentitled to the leave if they don't tell you in advance. So they can tell you retroactively. There's no set time to the leave. They can take it in, random days. They can take it in part days. If they take, 2 hours to go and deliver a prescription to somebody that they're caring for, you're obliged to let them return and complete the rest of their shift. So it's a bit of a scheduling nightmare. But to answer the question, they don't need to tell you in writing. They can tell you orally.
So I think we're getting into a lot of repeats here, and we've had some people say thank you and goodbye, and I got a hey Dirk, that's nice. So I'm happy to answer some more questions. I know that Isaac, you're back online. Perhaps this is a time to call an end to things.
Well, I don't think we ever really call an end to things. There were a lot of good questions. A lot of people had the same issues. I just want to thank Dirk and Mariana. You guys did a wonderful job. I'm pretty sure that the people who want more information will contact you. Once again, it's been a wonderful relationship that we have had with you, and we continue to have with you. And it's just a difficult time right now, so people have a lot of questions. So I invite everyone who's still on this particular webinar. There's 152 of you still on this. Contact MBC if you have any questions, and you'll get your answers. And stay healthy, stay strong, and let's hope we can get back to work real soon. Everyone have a really wonderful, wonderful rest of the week. Thank you for joining us. Special thank you to our speakers, Mariana and Dirk. Thank you all. Have a wonderful day. Thank you.
Thank you, Isaac.
Okay, thank you, Isaac and Henry.